regular listeners, you're all very welcome back to part 3 of my very interesting chat so far with Des Carty from the Common Law Society. We're talking about the book Irish Life and Me, Tales of the Criminal Cabal, and things are heating up as we take it kind of chapter by chapter. We're heading into chapter 3, which is intriguingly entitled, Des, Mac the Knife. Let's talk about it.
All right, John, thanks very much again. John, could we just remind listeners as well of what we covered briefly in chapter 1 and 2?
Absolutely.
The main proponent of what we were talking about in chapter 2 anyway was putting in the Data Protection Act request, which inevitably gives people more time to understand and deal with these matters. So again, just to remind your listeners, if they put in the Data Protection request and Freedom of Information request as is delineated in the book, it will give them 40 days plus in which to learn a bit more and learn to understand how to put in other questions and other sort of daggers into the bank, if that's the right phrase.
Yeah.
Okay, that's just basically it. I think there isn't much more to say or state on that. And sure, we'll get off into chapter 3 then, yeah?
Okay, so you've bought your 40 days.
Okay. Well, within the 40 days, obviously, the man, we call him Tom, did a lot of study, and he took a good bit of direction from us. And we in the background were studying also, and we had a look at his papers, his paperwork, and the documents that were coming in or had been sent in by the Permanent TSB and Irish Life. And we discovered, now when we look at stuff, we critically analysed it, and it wouldn't just be me, it'd be a whole group of lads here and girls.
Yeah.
And they'd sit down and we'd pass it round to see if there is anything in the letters worth noting or worth interrogating. And one of the things that we discovered was, down the foot of each of those letters at that time, this is back in 2012, we discovered, we were looking for the names of the directors of the Permanent TSB at the time anyway, and we noticed that there was a one Ray McSharry as listed as being a director of Irish Life and Permanent TSB. Now, we did a bit more research, and our understanding is that at that point in time, the same Ray McSharry was also a director on the board of the Bank of Ireland. So, for those listening to this, some people will not have heard of the name Ray McSharry, but they should Google it and do a bit of research on it. And Ray McSharry was one of Charlie Haughey's, who was an ex-Taoiseach of Ireland, one of his right-hand men, or a henchman as some people call him, and he was actually given the title Mac the Knife because of some of the things he did. So he cut and slashed and burned and so on and so forth. But in summary, we thought it was interesting to note that Ray McSharry was a director. Now, I don't know if he still is, so listeners can check that out for themselves, but at the time he was. That he was a board director with the Permanent TSB, and he was also board director with Bank of Ireland. Now, that in itself is a conflict of interest anyway, because he's then a board director on 2 banks.
Yeah.
So that's one thing. And then we did a bit of research into Ray McSharry. We knew we'd find stuff on him, and obviously he was involved in meat scandals and literally involved in, if you like it, the Irish Watergate, which was phone tapping, and on behalf of the political parties of the day run by Charles Haughey. So he was directly involved and implicated in these matters. Now, I can't honestly say if any criminal prosecutions took place, or I don't honestly believe they have. But that was fine. So we did a bit more researching on Ray, and we also found out that at that time, back in 2012, he was involved himself in a high court action himself, and I think 1 or 2 of his sons. And then we did a bit more research, and we found out his daughter was also on the board of the Bank of Ireland as well, in relation to, I think it's the Bank of Ireland Court it's called, or something like that.
Nice and cosy.
Sorry, John?
Nice and cosy there.
Oh, very cosy. But look, it's typical of Ireland in that you have a political aristocracy or oligarchy, whatever you want to call them, in these key positions, in senior positions in government and in the state and on the banks and so on and so forth. So it is typical of a political aristocracy. In other words, these are intergenerational people that have passed on their wealth and their, I suppose, I don't know what else you call it, but their power on to their children and their children's children. So that's why we'd call it a political aristocracy. But at the heel of the hunt at the time, now this is when the man Tom was writing to the bank, we discovered this. And at the time, we had also been speaking to a couple of people from the financial services sector who had been, who were on their way out of the financial industry and were being throttled themselves in relation to their own companies hammering them. So they were feeding us information about what was going on, and feeding us information also about the relevant acts and statutes and codes that we could also use. So we were pointed in the direction at the time of a thing. Now this leads us into chapter 4 from there. The points I've just made there, you can see them in chapter 3 anyway, and they're just points of note.
Yeah.
And of course, apart from the obvious conflict of interest, the key point the key act that we were directed to was a thing called the Central Bank Reform Act 2010. And more specifically within that act, we were pointed to a thing called fitness and probity.
Right.
And these are questions, if you like, and assessments of the people that work, for all the people that work within the financial services industry, as under a thing called control functions. If they have a control function, i.e. a manager, a director, so on and so forth, they have to be fit and prove their ability to be able to do the job, not just from the perspective of not having a criminal record, so on and so forth, but financial perspective as well. So it's a whole rounded thing. And specifically under the Central Bank Reform Act, there is a set of questions that should already have been answered by the respective people within the financial services sector. And that would have included all directors and all managers within Irish Life and Permanent TSB. So we just simply dug out those questions, and we helped Tom pen a letter to the bank, and each one of these letters would have been sent to every single director at the time of Permanent TSB stroke Irish Life. And the questions range, well, the heading, I suppose, for the questions is, in general, it's fitness and probity standards that are required that the persons in the control functions must be, and there's 3 points here, they must be competent and capable.
Yeah.
B, they must act honestly, ethically, and with integrity, which is a bit of a laugh. And C, be financially sound. Now, we're sure they're financially sound. How they got to be financially sound, I don't know. But as we are aware, both Charlie Haughey and the other Taoiseach of the day, Gareth Fitzgerald, both of those Taoiseachs had debt written off for them by the respective banks that they were involved in.
Yeah.
I mean, literally, the banks did actually write off their debts. So, going back to this question of, well, the best example we could choose that we did a bit of research on was Ray McSherry. Was or is Ray McSherry fit, and does he fit the fitness and probity standards that are required of a person within the financial services industry? So competent and capable. Well, he probably is capable and he probably is competent. Now, capable and competent of doing what, I don't know. And given the fact at the time of writing, he was involved in somebody suing him and or his company on the day in the court. Okay? It's in the High Court. And this is, you can check out the Irish Times on this, and this was logged. Then, if such a man was involved in the likes of meat scandals and basically financial wrongdoings,
yeah,
and also in phone tapping, can you say the man is honest, ethical, and has integrity, which is part B of fitness and probity?
Yeah. Well, it's going to be very difficult to actually come to that conclusion. You know what I mean?
Yeah, it is. It is. Look, just on the outset of it, it's going to be difficult. And then be financially sound. So that means that every one of those directors, managers, so on and so forth, our type Permanent TSB would have had to submit a statement of some sort, a statement of means, a statement of how they are financially. So we thought, well, if these questions are already supposed to be answered, these questions should have already been with the central bank, then there'd be no harm in Tom asking the same questions.
Yeah, of course.
So I think in total there was 27 questions, and it ranges from, and I'll just read one or two of them out. And the first one, the letter that was written, was to Kevin Murphy. Are you, Kevin Murphy, approved by the Central Bank of Ireland or any of its predecessors? Okay, so a very straightforward question. Is he approved by the Central Bank of Ireland? Now, this is as a man within a control function. That's the context.
Right.
So all we wanted to know was he certified or approved by the Central Bank to operate within that function. And the questions go on then to say, if you are, can you prove it in writing as specified by the Act? So again, we're referring back to the Act and saying, look, if you are approved by the Central Bank, please provide us with demonstrable evidence, i.e. proof. And this information and evidence should already be with the Central Bank. So the next one was, now we won't go through them all, John, because it would take us a year and a day.
Yeah.
The next one, again, is, do you have or will you have any shareholdings in Irish Life Permanent PLC, Permanent TSB, or its group of companies? So a very open question, just asking what shareholdings they have. Because again, if conflicts arise, well then you'll know why. Then the fourth one, do you have any current or previous business interest shareholdings in any financial entities or other organisations, including the non-financial sector, charitable and or not-for-profit organisations? So again, all these are sort of questions whereby you're just asking them to divulge the information that is already and should already be in the possession of the Central Bank.
Yeah.
So this letter was sent off. Let me just get back to the date here. I think it was in April or May. Let's check it. Sorry about this, John. I should have checked it before I said, yeah. Back in April, this was sent out of 2012. And again, within the context of asking the questions, we've defined certain things for the parties in terms of what extortion is and so on and so forth. Now, the question I'd have for you, and you probably already know this already, we put at the end of the questions, 27 questions. Now again, all these questions, every single question was sent to every single director of the bank. It was also copied into all the other parties that were relevant to the writings, which would have been the Central Bank as well. So the note we put at the end of the questions was, note, if you fail, refuse or neglect to answer any of these questions within the allotted time frame, and I think we gave them 7 days or 10 days, I'm not sure, it will be deemed that you have purposely and willfully breached the Central Bank Reform Act 2010. Therefore, a notice-stroke demand will be issued for a full, proper and immediate investigation to be carried out, with a formal entreaty submitted for your instantaneous suspension-stroke dismissal. This will be treated in the public and will be supported and noted by an official notary. So we'd have it on record by an official notary to say, yes, all this is true.
Yeah.
So that was fine. Now, the question for yourself, without getting into the next chapter, do you think they answered any of these questions, John?
I'd be very surprised, Des, if they did. Very surprised indeed.
Yeah. Now, you're right, obviously, because these people do not answer questions, as we referred to before in the introduction.
Yeah.
These people are picked and chosen to do the right thing and say the right thing, or not say anything at the right time. So, no, we didn't get any answers to these questions, but we did follow it up in the next chapter with the notice to commence investigation. So, the listeners need to tune into this. They're very serious questions. They're being asked of people who are perceivably in authority, and they failed, refused, and neglected to answer that. Now, alongside that, they perhaps still have people working for them as directors and board directors, so on and so forth, with very nefarious dealings in historical dealings. And I'm not sure where Ray McSherry is at the moment. Perhaps he is or isn't working for a bank. But I can't understand how a man like Ray McSherry, given his history, could actually get a job and be appointed to a bank. And not just one bank, but two banks. Now, he may be a director of other banks and other institutions, so on and so forth. But I just don't get that. How a man with that background could actually get a job if he honestly answered the questions that would have been asked of him and should have been asked of him. Now, given this fact, now I think people need to tune into this again. These letters were not just sent to the directors. These letters were sent to the relevant ministers. The minister was sent to Michael Noonan, the Minister for Justice, Alan Shatter, and it was sent directly to Patrick Honohan, who at the time and still is the head of the Central Bank of Ireland, and his colleague Matthew Elderfield. So I just don't. Again, none of these parties, responded to any of these letters in any context whatsoever. They didn't even acknowledge. In most cases, I think the Minister of Justice acknowledged he received the letter, but that was about the height of it. But the rest of them just did not engage in any context whatsoever, and none of the directors wrote back, and certainly Patrick Honohan did not acknowledge or write back. Now, we know he got the letter because all our post is either recorded or registered and or emailed as well.
Yeah.
So we know these parties got these letters, and they're probably just sitting there. They're probably in the bin, as far as we know.
And I think it's worth jumping in at this point, Des, just to say, because this is used against the common man or woman all the time.
Yeah.
When people choose to kind of bury their heads in the sand, or because they're terrified by the letters that come through the door from legal entities. Like, ignorance of the law isn't any defence, and it applies just as much to director of a large bank as it does to somebody who's struggling to pay their mortgage.
Absolutely. Yeah, that's a very good point. That's why we wrote in this form, in this context, is we thought, well, we'll put it all on record, and if it ever does come up whereby the man is faced with the court, then legally speaking, the man could call into play any of these directors. Patrick Honan could be called into the court because they are now culpable for either their acts or their non-acts or their behaviours or omissions. So now this brings them in, and this is a question we got on an email there during the week. What was the purpose of copying the letters to everybody? Now, I think we answered it before, but it's worth answering again. What you're doing is, by sending the letters to all parties, now we don't say carbon copy, we say and for the attention of. So you'd have for the attention of at the very top, and then you'd have and for the attention of other parties. That brings them into the matter. It inculcates them, as the word goes. It means that they're now involved, and they have no choice but to take heed and cognizance of what has been written and what has been said. They also then have, by bringing them in that way, as opposed to just carbon copying them, by bringing them in that way, they now also have a duty of care to make sure that all the right things are done by law and legally. So this isn't just a matter of writing to one man in a bank or one woman in a bank and saying, look, you need to do your job, you need to answer these questions. All the parties now that are listed in these letters now are culpable. They're culpable and they're liable for prosecution if things don't go right, or if things do go right, for that matter.
And Des, there will be some people listening in now and they're thinking, well, these people don't care, they're just going to keep ignoring. But the point, I think, is that we're building up an armoury. It's ammunition for the case that may or may not come somewhere down the line, and all of this can be used at a later date. So even if you're not getting responses to your letters, that's something that you can use to arm yourself and equip yourself in a positive way with if battle commences somewhere down the line.
Yeah, absolutely. But again, John, look, I'd refer back to, we've been at this for some time now, directing people, helping people, so on and so forth. And to be honest with you, most of these matters just dissolve away. And if you get the right paperwork in place pre a court issue, or pre, say, a summary summons or a summons being issued, they will not bring you to court if you get the right frame, form, content into your letters. They don't want to be faced with this, because the trouble is with the system, we said the banking system and the judicial system. If a bank fails in the High Court, or let's say fails on appeal in the Supreme Court, that's basically the end of what they can do for everybody. They can't do any more if they fail and they fail to prosecute somebody. So by building up your armory, as you suggest, you're learning the rules first of all as you go. Then you're learning to make a few moves. And very soon, and I think we've said this before, very quickly or very soon into the process of this learning and this new knowledge that you might be gaining, you will be pretty astute, and you'd probably be pretty much in advance of the average, I suppose, the average Joe Soap of the solicitor that's out in the average town. Now, obviously, we said before, some solicitors are better than others, but the majority of solicitors do not read legislation. They do not go into and study the acts. And we know this because we engage solicitors and barristers every day of the week. And they do not read the material that is available. Now, having said that, 95% of the population don't read it either. But if you can read it and get your head around it, and in the context of writing a letter and looking at the book, so on and so forth, then you will exceed the average solicitor, And most solicitors, after 1 or 2 letters, they back the hell down. They don't want to deal with these things. Now, again, as you and I both know, there are solicitors out there that are more vociferous, more aggressive, but at the heel of the hunt, they still don't want to go into court and be shown up to be fools.
True, yeah.
So, it's that simple. I mean, if you, this is where we'd also hope that people will gain some confidence with the knowledge, and then say someday, well, actually, I don't mind going into the court now because I've actually built up quite a substantial case behind me if it ever happens, if I ever needs to go into court. So that's another story for another day, I suppose.
Yeah, absolutely. Well, I think you've gone through that very nicely. Most people should have a fairly clear picture now of why these letters are being sent out to all these other parties and not just in direct response to the original letter that comes through the door, and the power that can give people, because essentially, and we harp on about this all the time, but it's about taking back the power that you have tacitly granted to a third party, and you don't have to give your power away to anybody else, and that's the crux of the whole matter, and a lot of people don't really realise that.
That's correct. I can't add anything to that, John. You said it perfectly.
Fantastic. Well, that brings us up to Chapter 5, which we're going to talk about in depth next week. It's the notice to commence investigation, and things get very, very juicy. Is there anything you'd like to round off our chat today with? Yeah,
John. Just to let listeners know as well, as we get further into the book, we will also talk about summonses, because the summonses are covered, and we recently did an article, and if people want to tune into it, they can go to thecommonlawsociety.com. It's about summonses. I think we send out an email as well, but it's well worth looking at it in the interim before we get into the summonses issue, because it will show anybody that is afraid of getting a summons how to deal with it from different perspectives, from the perspective of knowing that it might come, to hearing a knock on the door, to receiving something through registered post, an ordinary post, and so on and so forth, and then how to handle it if eventually you do get served with the summons. And we wouldn't recommend people get served with summonses, but again, it's not something you need to be afraid of. There is a way to deal with it and a way to handle it that won't bring you into the court's jurisdiction, which is what people are afraid of primarily.
Yeah.
But we will demonstrate that. We'll talk about that now. It's often a slight tangent later on, but I want to make sure we get it into this set of interviews, because I think it's going to be very, very helpful for people. And that's all I want to say, John. Thanks very much.
Fantastic. Well, great to have you on again, Des. Looking forward to our chat next week. Enjoy whatever the weekend and the week ahead brings. And we'll chat again very, very soon.
Thanks a million, John. Take care.
Thanks, Des. Talk to you soon.
Good.